council's ready to go. Let's see how we go. Court rise.
Yes, Mr. Fleming.
Lord, the point I was making before we rose is that the commissioners seek to derive support from the distinction drawn between goods, including books, newspapers, and electronic supplies, as we see in the Sixth Directive and in the Principal VAT Directive. I hope emphasise that we do not say that Article 98.2 provides the answer, but there is a strong steer. There's another reason, one can follow this through the legislation which I was seeking to do when I was first addressing you. But when you get to 110 itself, it's dealing with reduced rates and zero rates. So it covers both. And it applies to pre-existing reduced rates and to pre-existing zero rates. The only difference is the tax. One is 0 and one is less than 15%. It won't be 0. So assume for a moment, just to test the argument, assume that the UK back in 1972 had taxed newspapers at 5%. Then when one looks through the statutory framework and you're asking about what is the reduced rate about, you look at the legislation in the UK and you'll see that they have reduced rate provisions and they differentiate between books and electronic services. We say that's helpful, but we don't go further than that, save to take it this stage further. When the EU legislated in 2018, it legislated to allow member states to apply a zero rate, reduced rate, to electronic services for the first time. And the so-called harmonised rate that the learned friend refers to, the harmonised reduced rate, is not mandatory but discretionary. And it may also apply, when we look at the directive, to a reduced rate which may have been permitted under Article 98. It may already have been applied by a member state before January the 1st, 1991, or before, in our case, 3rd of December 75, or back to the 11th of April 1967 for others, which is the date of Article 17 of the Second Directive. But all those pre-existing conditions are recognised in 110, and then when you look at the directive in 2018, page 40, the court will see that the legislation is dealing with zero rates at all. Sorry, zero rates as well. So if one reads through the third recital, it introduces the possibility, this is in the third recital, for all member states to apply a reduced VAT rate to the supply of books, newspapers and periodicals, irrespective of whether they are supplied on physical means of support or electronically. For the same reason, it is appropriate to allow those member states that, in accordance with the union law, important introductory words, currently apply VAT rates lower than the minimum rate laid down in 99, or that grant exemption with deductibility of the VAT paid at the preceding stage, in other words, zero rates, to certain books, newspapers or periodicals supplied on physical means of support apply the same VAT treatment to such books. So the presumption, the starting point, is that the legislator is operating on the basis that there are reduced rates of different kinds. Member states may have had that ability when they joined the EU. They may have acquired it under Article 98. There may be zero rates, but they're now, for the first time, according to the legislator, being allowed to include electronic services. Which takes me to one point that my learned friend was mentioning, which is, how did this proposal come about, and are the views of the legislator and the Commission of any relevance, which takes one to paragraph 117 of the Lloyds case. Again, we don't say that the view of the Commission is authoritative. We say it strongly assists the Commission's case. But if this court concludes that the Commission has got it wrong, then perhaps the court should say so, as he did in paragraph 117 of Lloyds. Because if we turn to page 642, which is a page that the learned friend referred to this morning, which I hope is the right page. It's the disadvantage of the physical rather than the electronic. I have to get through the stages. Page 637 is the consultation, which was for a limited period in June 2016. And then you get, after the consultation, you get to the proposal for the Council Directive, which was dated the 1st of December 2016. And 642 is the page that my learned friend took or referred you to. But if the court could read the first paragraph, you'll see that again,
Sorry, 6.4, which page are we at?
642, my lord.
642.
You should have explanatory memorandum, context of the proposal.
Yeah.
And it starts with a reference to the Principal VAT Directive. Electronically supplied services, including electronically supplied publications, hereafter called e-publications, have to be taxed at the standard VAT rate. That's the starting point for the analysis. On the other hand, member states have the option to tax publications on any means of physical support at a reduced VAT rate, minimum 5%, and members were granted the possibility to continue to apply VAT rates lower than the current 5% super reduced rates, including exemptions with the deductibility of the VAT paid at the preceding stage, so-called zero rates, for certain printed publications. So we're outside Article 98. We're dealing with the three variants upon which you can avoid the effect of all electronic publications have to be at the standard rate.
When you say we're outside 98, it was inside 98, wasn't it?
Yes.
But the last sentence is outside.
Correct. So you then have the second paragraph. The VAT directive prevents member states from applying the same VAT rates, must include zero rates, to e-publications as they currently apply to physical publications, and the result is a markedly less favourable treatment of e-publications in most member states. Whilst acknowledging the difference between printed publications and e-publications with regard to the format, they offer the same reading content, which we know. And then you have the reference, the only point I was trying to make on goods and services, the only specific point, is this change that happened in January 2015, when the place of supply rules changed. So all of that, we say, suggests that there is a clear position in Europe, Commission and legislator level, that up until this permission was extended in 2018, there was no power, no ability, it would be unlawful, contrary to EU law, for the UK to extend their zero rate to include electronic supplies. That was the point I was seeking to...
When was the RPO case? Because according to Mr. Peacock, what the RPO decided, I think he was saying, is that they are comparable, e-books and books on a physical support. It is, I'm not sure whether he said that RPO decided it is contrary to fiscal neutrality to treat them differently, yes, but that Article 98 at the moment requires you to treat them differently.
It's rather more nuanced than that, but because they were, of course, in RPO dealing with with books and the reference to physical means of support, and it wasn't.
They were comparing e-books and books on physical means of support.
Right, but did they say that it was contrary to fiscal neutrality to? And what slightly surprises me, I'm not quite sure when, I can't remember when RPO was, but there doesn't seem to be any reference in the consultation document or the explanatory memorandum.
2017.
It's 2017, and it's specifically referred to as part of the debate as to why there should be a change. It should be in the either in the directive itself. I think it's a footnote in the directive in Europe.
Yes.
At page.
Yes, I remember.
If you go to the 2018 directive on page 40, you should see there's a footnote. So could I take you to the directive itself? The recitals are on page 40, of course. And Council Directive provides that Member States may apply reduced rates of value-added tax to publications on any physical means of support. However, a reduced VAT rate cannot be applied for electronically supplied publications which have to be taxed at the standard VAT rate. Then they accept that the world has changed. And you get in the third recital, well, in fact, I can start in 2.
Yeah.
The 2, it really starts the story. So in 2015, it was beginning to be recognized as we moved into the e-commerce directive, which was about that time, that done about this. Because as to content, certainly by 2015, there's never been any dispute. In front of the FTT, we sought to argue and failed to say that it isn't the same as the printed newspaper, because you have videos, you have games.
Yes, but just in the middle of
the third
recital 3, where it says that the court in RPO held that they amount to comparable situations.
Yes.
Is that phrase a sort of magic phrase that's used in fiscal neutrality cases, or
it's certainly relevant to fiscal neutrality, yes, because you would have similar products, and you would then find yourself potentially in this problem. The reason fiscal neutrality doesn't work here, of course I'll get to it, is if you are with the commissioners on the first point, you will have decided that the essential characteristic, one of the essential characteristics of the British regime is that this is a printed document. So when it comes to this genus of facts argument, which itself is slightly dangerous, the genus is printed documents. So what you can't do, and what couldn't happen in various cases, and you can see this, you can't use fiscal neutrality to extend the scope of something such as a zero rate. What you may be able to do, may have to do, is get rid of the zero rate so that there's no imbalance between the standard rated and the zero rated. What you can't do is both. And in sub 1, paragraph 64, which is really the important paragraph, the paragraph before, you'll see the reference to Deutsche Bank, which we continue strongly to rely on, which says you can't extend the scope. In the next paragraph, Lord Justice McComb says, well, we don't need to worry about Deutsche Bank in this case, because everything is within food.
Yeah.
You haven't extended the scope. Now, here, the only way that my learned friend could use fiscal neutrality on its own is if he's won the first stage. And you can see that's what he's been trying to do. He's been trying to win the first stage in some way without winning it, which we're finding a little difficult to follow, and then says, aha, I've got a genus of facts argument, which I can pick out of my first losing argument and transpose to my winning fiscal neutrality argument. And he can't. An RPO doesn't get him there. All he gets from RPO, less from the Advocate General, is that there will be comparable situations, and that's why we need to legislate. And that's what the UK is saying. We, the UK, would like to legislate, but we have strictly interpreted zero rates. And I suspect, although I haven't got instructions, that when the consultation took place in 2015, 2016, the British government would input into that consultation and say, yeah, we're with you. But, and this is another point that we might have picked up as learned friend makes his submissions, what about legal certainty? What we have here is a provision that was brought into force in 1972 and hasn't changed at all. It hasn't changed, for example, to refer to CD-ROMs or other physical means of support, which was happening in Europe. And there are going to be differences. Take the lines that were perhaps being drawn in some of the exchanges. Learned friend wants to keep the Times as the beneficiary in this case because it gets a competition advantage over the Guardian or whatever, not the Financial Times, whatever the other newspaper is. So it's only a reproduction type case. But as soon as you start looking at purpose, then you start ending up with anything that delivers news. If that's what you're talking about, well, when did that change from 1972? Well, did there come a point when we, the UK, should have changed our Group 3 or exposed ourselves to claims for fiscal neutrality damages? Well, first of all, there's no right to a zero rate, you've got all of that. So, but there comes a point when you go through the history, you ask when, and that's a legal certainty problem which also applies throughout. So I'm putting it back, I hope you get the point. Could I just make good, it's the point I was seeking to emphasize is the Upper Tribunal didn't merely say, we don't agree with the Commission. We don't agree with the legislator, the European legislator. We say their views are irrelevant. They may be irrelevant, and I'm finding it difficult why they are, if you're concerned with a purely domestic piece of interpretation, but you're not. You're here being asked to apply an always speaking principle, which itself is just another tool for interpretation. And it itself should be understood and applied in context. And we see some of that in Lord Wilberforce's dissenting speech. But we haven't had a case, and this I hope isn't the case that goes to the Supreme Court, where the always speaking principle is used to extend beyond a group, beyond an item, and without any reference to the European equivalent position, although dealing with internal, within the EU, reduced rates. That's why, just landing on one other case, Harrier doesn't help the learned friend at all. Paragraph 44 of Harrier, we have some reservations about, we the commissioners, because it doesn't refer to strict interpretation, time limited, etc. But in the scheme of things, it does because the tribunal judge, as my friend says, an experienced tribunal judge, asks the first question: is this photo book goods? Is it within the existing item of books? Or is it services? Because if it's services, it isn't in that category. And he decides that it is within the category, and it's then a question of, well, it's made up of images without any text. Is it therefore not a book? And that was the issue at the end of the case. So there's nothing in Harrier to assist my learned friend, but there's a lot we respectfully submit in the legislation in Europe and all the way to the directive that adds support to the Commissioner's submissions. But could I just make one submission on the various cases that you were shown yesterday and today, including Commission and UK, Marks and Spencers, etc. What my learned friend said yesterday, and he's backed away from it today, is that yesterday it was zero rating is entirely a matter of UK law. And he gave you the example of Commission UK, Marks and Spencers. If you look at Commission UK in particular, it's authorities page 60. What it shows you, without going through it, perhaps showing you one passage to illustrate the point. Page 60. What the decision shows is that zero rating, at least since the passing of the 6th VAT directive, was permitted by the EU to continue. So the first case we get is the UK. And the UK tried to argue, you can't touch us on our choices because these are domestic law choices. And you can see Mr. Advocate General Darman on page 65. And you get through the various constraints that you find in the final indent from paragraph 17 of the second directive. But when you get to the Corp judgment at page 144, see Article 28, which goes back to the last indent of Article 17. And at paragraph 4 and 5, you will see that the UK has continued to apply its groups of goods and services which are zero rated. And then the Commission comes in and says, we're not happy with this. But when you get to substance on the next page, you'll see that it should be pointed out, first of all, that the Commission does not dispute the legality of the system of zero rating. In general, it considers that system to be essentially equivalent to the exemptions provided by Article 28 of the 6th Directive, as it expressly stated in its proposal for the 6th Directive in 1973. So the link is already there between what's inside Europe and what's retained by the joining member state. And then, of importance, is the UK retains some discretion. This is why I've been struggling with this ground playing field reference. The concept of clearly defined social reason. With regard to the first condition, that is to say that exemption may be granted only for clearly defined social reasons, the parties are agreed that the determination of their own social policy is a matter for the discretion of the member states on subsidiarity grounds. They accept, the UK and the Commission accept, however, that discretion may be subject to supervision at the community level. So we've already got the interaction between Europe and the EU. And without going through the various rates, as my learned friend mentioned today, were put under the European microscope and were struck down. You'll see, for example, paragraph 25, and in relation to the news service, which is close to ours, paragraph 29 was also accepted. So what you find is from Commissioner UK and Marks and Spencer's, and indeed many other cases, that there is an area of discretion left to the United Kingdom, but it isn't unpoliced, even when it comes to policy, near political choices. Marks and Spencer, you'll see it in paragraphs 37 and earlier in paragraph 22, the exemptions are permitted. That's the language that you get in those cases. And if you go outside the constraints, which will include, as we keep saying, strict interpretation, standstill, social purposes, etc., they will be subject to European supervision. And the final one of the cases is Commissioner Luxembourg, also mentioned by my learned friend. And this is an example. It's for your note, page 2. Could I invite you at some time to look at paragraphs 33 to 50 and 66 to 67? What you see for that case is that the European Court of Justice and the Commission, as the infracting body, take a serious and strict approach to any extension of the exemptions. We say that, be that a reduced rate, super reduced rate, or zero rate. And the Commission, through me, remains concerned that there is a real risk, even at this last hour, that if the UK, by its courts, extends zipping to electronically supplied, whatever the phrase is, back to 2010, that will be a potential breach of European law with infraction proceedings. Could I, before I leave this European position, my learned friend made a slightly odd criticism of the domestic legislation. The domestic legislation, as of the 1st of May, when we all get our 20% reduction, looking forward, is said to be framed with a very natural use of the word newspapers, a natural use of the word newspapers in the context of the new regime. It is the European, the British draftsman has been careful to use the language of the 2018 directive. So if you go to page 57 of the authorities, this is the extension order, statutory instrument 2020 number 459. And what it adds is an extra item. Publications, in other words, 1, 2, and 3, books, periodicals, newspapers, etc., without saying what they mean, reads as follows. The publications listed in items 1 to 3, when supplied electronically, but excluding publications, will be zero rated. So there's no extension of the word newspapers, save by adding, which is a text taken from the 2018 directive, when supplied electronically. Recognizing, of course, that in 2020, on your iPad, your phone, you can do that which you could not do in 1972. My Lord, I hope that's sufficient expansion of my brief summary before the short adjournment on why we say there's relevance in what is happening in Europe. And could I then make two submissions on strict interpretation and move on? My learned friend has said more than once that he accepts that there needs to be a strict interpretation. When he explains his reasoning, he doesn't use it at all. He, as he says as well, he applies a purposive interpretation, saying anything that advances education or information is okay. What we haven't heard is if he's wrong and should be applying a strict interpretation, what does that mean? What would that do to the word books? What would that do to the word newspapers? He tried by saying, well, it won't include rolling news services. Well, that would come under telecoms probably, but others may say it's part of news. But the fact that he can't grapple with strict interpretation, say by going off-piste altogether, suggests that he is not applying it, and nor is the Upper Tribunal, see paragraph 89. What the Upper Tribunal had to do was to invent this middle ground, so that instead of a strict interpretation, indeed instead of the caveats and constraints imposed by the speech of Lord Wilberforce, what you have is a broad, permissive interpretation, and that is wrong. Well, unless I can assist you on the first major ground, that's all I wanted to say, and I can be very short on fiscal neutrality. You effectively have our submissions on that already. We say the First Tier Tribunal got it absolutely right. Judge Brannan's analysis is correct. And you can see where the error that I was pointing up earlier goes wrong, reappears from a learned friend. Again, without taking you to it, could I invite you at some stage to look at paragraph 61.3 and 61.4 of his skeleton argument, which is in the core bundle at page 71. So if I could read those out, you'll see what I mean. Here the principle, which fiscal neutrality principle, operates to ensure equality of treatment between newsprint newspapers and digital items within a category, indeed within a single word in the legislation, and not equality of treatment as between one category and another, thereby begging the question. In the next paragraph, a conclusion that properly construed the zero rating provision that the UK introduced in 1972 encompasses digital newspapers is a recognition of the scope of Group 3 Item 2, not an extension of it. So what he's done is to say that there is a fiscal argument within the same category, but he's lost that argument because the category is limited to printed. I hope I'm explaining the position.
I suppose fiscal neutrality can be a different point, which is how it was presented, but is it also a factor that goes into construing the word newspapers in this context? One concern I have is that the words books and newspapers and all the things that there are mentioned in the different items in Schedule 8 probably are used as words in all different sorts of statutes. And one doesn't want to say, well, it might be preferable not to say the word newspapers does not include digital newspapers as a general ordinary meaning of the word in every context in which that word is used across the statute book. But if if one is then saying, well, we're construing it in this context being that it has to be in accordance with community law, and we have to construe it because it's part of a standstill, because it's part of a derogation, because it's a word that's used elsewhere in the harmonised VAT Article 98, and that should be reflected. But is fiscal neutrality another factor like that, in addition to well, if I lose on the first point, it's a second point?
Well, the case law suggests not, because what you end up finding in the case law is fiscal neutrality is not a tool to extend a category. And we've got those
That
references.
slightly begs the
Yes.
question, doesn't it? Because is
Is it an extension or is it just an interpretation?
Is it we say it is for obvious reasons, and that's why we rely strongly on Deutsche Bank in which is the relevant paragraph is in paragraph 63 of sub 1. I haven't come across an argument, a case where, as an aid to interpretation, fiscal neutrality takes a separate role or somehow moderates the strict interpretation which is required in order to preserve and restrict and apply a standstill to a zero rate, remembering that zero rate is a derogation. So I haven't seen as a method of interpretation subject to It's really there is no case. It wasn't that I wasn't passed a note saying there was a case. the note from Mutual Finance is, if it's not an extension, why do you need fiscal neutrality at all? What Milady is asking me is, when you go through the first process, should you be throwing into the mix strict interpretation, fiscal neutrality, standstill, and how can strict interpretation and fiscal neutrality live together is the question I'm throwing back at you.
Yes, bearing in mind that the effect in this context of construing it is that there is then quite a stark difference in the tax treatment of supply A and supply B if they are not both incorporated in the same work.
But they are now. That was the point I was going to next go to. This becomes then, is it a judicial solution, or is this where Lord Wilberforce's last sentence applies? What the court would then be doing is extending the scope without doubt, and you would be doing without, and by doing that you would be filling a gap. And the gap is there because zero rating is tight and restricted, and the world has moved on. Now, that doesn't bring in always speaking for the various reasons that I've offered, but if it is now creating an unfair situation, then legislation is the answer, not judicial rewriting of zero rating. And the passage that we rely on, different in kind, which we still say is correct, strict interpretation, not broad or permissive, and finally, the courts must not fill the gap. And that again takes me back to legal certainty, because if fiscal neutrality is applied, it must apply across all of those items in Group 3, potentially. And when, at which point in history, did those items become comparable with the now online versions? We've been, of course, focusing just on the Times. Indeed, we've been focusing on the iPad. This case is all about the ability to pick up an iPad and scroll across so you have the impression that you're reading a newspaper, and that was explained by the editor when he gave his evidence. So we say fiscal neutrality doesn't help the respondent if he's lost the first one, and he doesn't win the first item by the court bringing fiscal neutrality into the analysis. Lady, I hope I've at least attempted to answer the question. On sub 1, we only, you will now have at some stage read the exciting story of the subs, the marinaras. Again, the important point to keep in mind is that that is different from this case. It's different because you have, first of all, you have a heading, then you have an exclusion, and then you have an exception to the exclusion. So it's a question of interpreting the exclusion and whether or not that was a misinterpretation of domestic legislation. At the back of the case, you'll see this appendix of the various decisions that have been going one way or the other. The important point is Deutsche Bank. And could I just show you 2 paragraphs and then say no more?
Are we looking at it in sub 1, or are we looking
Sub 1. Yes. Sub 1 is in the bundle at page 482. Deutsche Bank is in the authorities, but I'm taking just to the short extract. And I think we'll find it in Justice McComb's judgment around paragraph 60. Yes, it's 61. There's the main relevant extracts. And perhaps I should have stopped and also mentioned the Upper Tribunal and Mr. Justice Arnold. When your Lordship, your Ladyship, reread paragraph 60, which is the 2 paragraphs from Mr. Justice Arnold's judgment, and you see that in paragraph 80, he says this: it does not follow, this is D, that the UK can draw the line in such a way as to discriminate between objectively similar supplies. On the contrary, Article 110 is explicit that exemptions must be in accordance with community law. In my judgment, Marks and Spencer makes it clear that the maintenance of the exemption is only permissible insofar as it complies with the principle of fiscal neutrality. So we're looking at within the exemption. Then you get to Deutsche Bank, and over the page, again without taking you through it to the end, lastly, this is paragraph 45. In paragraph 63, you'll get the reference to the Advocate General saying, while the principle of fiscal neutrality in VAT may explain the relationship between the explicit exemptions for both direct investment and the management of joint investment funds, I do not accept that it can extend the scope of an expressed exemption. We say that's what would be happening. And paragraph 43 of the judgment. Lastly, it must be stated that that conclusion is not called into question by the principle of fiscal neutrality. As the Advocate General stated at point 60, the principle cannot extend the scope of an exemption in the absence of clear wording to that effect. That principle is not a rule of primary law, that's fiscal neutrality, which can condition the validity of an exemption, but a principle of interpretation to be applied concurrently with the principle of strict interpretation of exemptions. So what you can't do is extend the scope of newspapers, which we proceed upon the basis that it's paper, it's goods, for all the reasons that we've been going through. And you can see that it is an extension of the scope by looking at what was happening in Europe, because they had to add in Europe physical means to the word book to get in CD-ROMs. They had then to add what we now get in the 18 directive. And when it came to cassettes and whatever the other word is in Sweden, that's a specific exemption.
But we didn't have to do that because Note 1B adds services in respect of.
In respect of the goods.
Yes.
So it's still.
But we didn't have to add. We proceeded on the basis that that was encompassed within the original phrase. Otherwise, it would have been an extension. When that note was added, we must assume, mustn't we, that the draftsman interpreted it as articulating what was already there.
Was what, and you'll find it in Europe by then already, is what that was authorizing is lending books, for example, which didn't give a transfer of ownership. So it was something less than the transfer of ownership in the concept of a physical good. And what you see through all of those notes is in relation to those goods, you can do certain related things. And that's the same as in the, by this time, the 6th directive, when looking at the list of goods which deals with books, including library loans. You had to extend that exemption to include the possibility that the books that are zero rated aren't being sold.
So you're not making the point that services couldn't have been envisaged. You're saying it's still got to be related to a physical thing.
I'm saying that services aren't in the list.
But services is.
No,
1B.
not in the list of items. There's this additional note that says in relation to those goods, you can
include these services.
Oh, well, so then I've misunderstood that.
I have too.
So are you saying that just as my Lord the Chancellor pointed out, the 2008 directive was implemented by expanding the scope of item 3, whatever it is. So that expansion of the scope by the addition of Note 1B was a response to some liberalising measure it made in the EU state.
Lady, I can't do that without getting the timing right. But I do know, and we've seen it already, that within Europe, the list of goods, books, etc., includes, I think, reference to libraries, unless I've misunderstood it. Lady, I can't go so far as to say that it was triggered by a.
No, I'm not asking about a timing point. Let me try and express it. I had thought, looking at that note, extending it to library lending, which is a service, that was legislated for on the basis that the justification for including library services was that they had always been zero rated and therefore had been included in the national on-accession carve-out.
I should check to see that's right.
But, well, I thought you were now saying it's not right. I thought you were now saying that at some stage there was the EU legislation and the harmonised neck of the woods was enabling member states to apply a zero rate to library lending, presumably when people started to charge for library lending, which they hadn't before, and that was why it was included, in which case it wouldn't matter whether it had been in the 110 neck of the woods.
Lady, I think I do, but all I was trying to do was to recall what was in the European legislation. And I don't know whether it was in before this change or after. If you look at page 13, this is the European 6th directive, which was enforced as at 1992.
But the 1B went in 1978, didn't it?
That's what I was going to then check to see if there was a precursor to this.
Right.
But you'll see that the list in item 6 is supply including on loan by libraries. Now, on loan by libraries is, because of the language of goods, it doesn't transfer ownership.
Where are you looking at?
Page 13 is Annex H we looked at yesterday. This is the reduced rate of VAT, of course, because it's what became Article 98, 56.
Well, I think this is, for me, this is quite an important point, because I thought that Mr. Peacock was relying on the insertion of service of library lending to show that the legislators, in inserting that, must have assumed that the bespoke Article 110 exception, as legislated for by the United Kingdom, was not limited to goods, because there it is, they included a service as articulating what must already have been there. But if what you're saying is that that's actually implementing a derogation which is expressly allowed for library lending in the EU harmonised sphere, then that's not a good point.
I don't know on my feet. Could I have the opportunity, if necessary, to put in the reason, if there is one that I can find? This is, at this point, it does become a problem not having the officers who know about this sitting behind me. I haven't, as you will have noticed, asked for an opportunity to respond to the 1110, the 110 note that you were handed this morning. I hope I've covered all the points that may have been troubling the court.
Yeah.
I don't seek to put in a note, but if there's a point I've missed, I happily will prepare it. But I can't provide the answer, save to say that the point we take from those notes, which we've said before, is that all of them are referring to there being goods. Everything goes back to goods. But of course, as held by the Upper Tribunal, we're looking at the meaning of these words in 1972. What happens later is interesting, but it doesn't deal with the primary question, is what was intended in 1972. Obviously, we say paper, but in 1972, if it had said, instead of books, books including loans to libraries, would that make a scrap of difference to this argument? We say no. But that's my short answer.
Well, only that it makes a little dint in a strict services goods dichotomy.
Again, the services goods dichotomy was to show you there are differences, to show you by European reference that there is an important difference between books and electronic supplies. I don't need to deal with libraries at that point, but to say two things, that not only is there a difference between electronic supplies and books or newspapers, but that this mattered in both European and domestic implementation of European terms, and was picked up by the Parliament that passed the 2018 legislation by saying, as at the beginning of 2015, the place of supply rules have changed. That place of supply rule change was anticipated in 2006. It took, as sometimes things do in Europe, many years to fall into place. Until that moment, there was a stark difference between goods and supply, and you've had my submissions many times.
But it may not be as binary as the distinction between goods and services, bearing in mind Section 30, which right at the beginning refers to both goods and services in the context of the items. It may be that a strict construction of newspapers and books in 1972 simply excludes electronic versions of them, which are not a service which was contemplated, understood, or is implied at that time and in that context. And it's quite clear that over time, a very clear distinction developed between electronically supplied services and physical services. So, I mean, the fact that it's not a service doesn't answer the question. The fact that item 1.2 contemplates a kind of service in relation to goods, you say, well, it's just a service in relation to goods, which is one, I mean, that's a semantic way of putting it, and I understand why you say it, put it that way. But I don't, for my part anyway, I don't see this, the very stark distinction that you started yesterday morning by making, as being the real solution to the problem. I think the question is, what is the strict interpretation of the words in the books and newspapers in the correct context, using the correct means of interpretation required by European law. And all the, you know, we've mentioned a lot, but we've never really tried to do it all together. And I think the salami slicing that's gone on in this case, to say, well, now start with the English law, and then when you've got the English law answer, look at European law, that to my way of thinking, must be the wrong approach. It must be a single exercise in construction, understanding all the rules, including always speaking, including legal certainty, including fiscal neutrality, etc. And I think one has to be extremely careful here not to allow one of these supposed rules to overtake all the others.
My Lord, I don't disagree with that. I have some hesitation over the use of fiscal neutrality.
Well, I mean, fiscal neutrality is I agree, I mean, it has to be understood before you start using it as a tool of interpretation. But what the point I'm making is a more general one. And I think this case has been bedeviled, really, by the idea that it's got to be done in certain specific stages without looking at the whole picture. It's a sort of silo mentality. And the always speaking principle, and we've got all these recent cases on it all of a sudden, which is quite remarkable. None of us had ever really thought about it until recently. Now we're thinking about it all day long. But by itself, it's not the only rule you apply. It's not the only tool you use properly to construe the words in a statute.
But, my Lord, I agree, and if I've been salami slicing...
Well, it's difficult not to, because
I've been
of the way the argument's gone.
No, I've been trying not to. I've had to unslice the salami because of the learned friend's approach. I say you should be looking at this with European glasses on, but also with British glasses. And when you have the British glasses on, you bear in mind Lord Wilberforce.
Well, exactly, and the key to this case, I think, lies in paragraph 89 of the Upper Tribunal's decision, because in paragraph 89 the Upper Tribunal thought it had to make the salami thicker, if I can take the analogy. Sorry.
Take out the spicy olives.
Well, but you get the point.
I get the point, yes. Entirely.
And it thought it had to do that for a reason, because it realized that if it was going to apply a strict interpretation to the word newspapers, as written on the page in that year, it was going to come out with an answer it didn't think was right. Now, whether it's right about the spectrum, I mean, spectrums are very attractive to judges, because judges always like spectrums because they can come out any part of the spectrum they like.
But you can't, spectrums are Yes, of course, they're helpful in a teleological sense.
Yes.
But if one is applying, remembering at all times that Lord Wilberforce was speaking in a different context some years ago, that you can't slide from strict interpretation to permissive and use a broad approach to deal with the zero rate. And just
Well,
'cause I-
particularly when zero rates are intended, I mean, you know, which bit of zero rates are intended to be strictly construed and not extended, didn't one understand? I mean, either that's what it is or it isn't.
Well, I've been trying to avoid the word reference to Europe, and I have no instructions, I must say, about a reference to
We're
Europe
cutting it fine.
on the 2nd of December. No, I was thinking of your Lordship and your Ladyships. Fiscal neutrality to be used to extend the scope, which we say it must do, of an existing zero rate in a member state, would be a novel application of that concept. This is why, although the commissioners have reservations about they have in the end no reservations about paragraph 64 of sub 1, and the result is interesting. If you read to the end, the taxpayer loses.
Yes.
Paragraphs 89 and 90 are particularly disappointing news for the taxpayer. But when one gets to 64, the reason that Deutsche Bank doesn't need to be applied is in one line, these are within the same exemption. And if the interpretation, that's how we read that paragraph, and therefore it's not a problem. But if your Lordship and Ladyships read that paragraph to say that Deutsche Bank doesn't apply to zero rates, then we would respectfully disagree. And we just make the submission at this point so the Commissioner's position is clear. I've, to use the technical phrase, banged on a bit about this topic, and unless you have any further questions, those would be my submissions and replies.
Well, I wanted to ask you about the timing point you made, sort of by a sidewind a minute ago. You said, at what point does this interpretation come into play? So obviously we don't know about digital services, the digital representation of newspapers and books in 1972, but at some point we do know. And you said, well, there's a legal certainty point there, because if you allow this to happen between 2010 to 2020, what happens to a digital paper produced putatively for the first time in 1998? I mean, I'm just making a date up.
Well, they'll be out of time for their tax.
No, I understand that.
I'm being more philosophical.
But that's what I thought you were, and I just wanted you to articulate why it matters, because if he's right, if Mr. Peacock is right in the argument he makes, then presumably it would always have been that at any stage a digital newspaper is created, it is zero rated.
Yes, all I was saying is that this is, in my respectful submission, a good example of where, bearing in mind the need for legal certainty as an overriding principle, this coincides with the last part of Lord Wilberforce's dissent. This is why I've been trying to link them. This is a debate that's been going on through Europe for years, and this is suitable for going forward rather than going back. And going forward would be a parliamentary decision as to whether or not the time has come, with Europe's permission, to seek to extend these categories. Whereas, as your Lordship says, if the always speaking consequence is that all the way back to 1972, this has always included any method of delivering the content of books, periodicals, whatever. And I can see some potential cause for disgruntlement, let alone those who are waiting to pounce if Melinda Friend's argument succeeds.
What do you say about the harmonized versus carve out principle. You see, Mr. Peacock waxed, if I may say so, very lyrically and extremely persuasively about there being one silo of harmonized VAT, which is entirely untouched by the proper construction of the exemption, which you get the benefit of when you join up. And we looked at Hungary and all the other countries that joined and saw that they all had the benefit of different exemptions for different goods. But then we see that the changes to the entirety of EU law of VAT, including the possibility of reduced rates on digitally
And zero
rates on digitally supplied services, is introduced into the English statute by this clause 7 that paragraph 7, whatever it is, of which we looked at just a moment ago. I'm puzzled by the sort of silo approach, because it seems to me that the twain have to meet at some point. You can't have an exemption. And Mr. Peacock said in answer to this question, oh, no, they've never done it. It was going to come in under Article 403. It never came in. There's never been a harmonized system. We're going to be governed by these exemptions forever, kind of thing. Well, we're still governed by the exemptions, but it does seem to me that there are now being introduced. I mean, it doesn't seem to me, it's perfectly obvious. There is a harmonized approach to VAT, leaving aside the continuing effect of these exemptions. And I wanted just to know what you said about how we are to properly look at those different
If I can
approaches.
go back to the overall harmonised, non-harmonised, there are some areas of VAT where the prime position is the position of the member state. For example, you can see in the infraction proceedings commission against the UK about the choice of reasons for your zero rating. Zero rating after you've joined is fixed. That's the important starting point.
Except for the carve-out.
I'm sorry.
No,
Well, it's, yes, because you can maintain the carve-out.
you can maintain the carve-out, but if there's any more zero rating, there may be some different zero rating in the regime.
Oh, sorry, yes, I thought you were implying, hence my eyebrows shooting around my face,
Yeah.
that somehow you could carve out of the standard rate more zero rates without the permission of Europe.
No, I
So
wasn't
my
suggesting that.
misunderstanding.
Well, I mean,
What we've been trying to get across is there is no watertight shield around because of these European principles. You find it expressly in Article 110. Article 110, I think, is the first time in this regime where you bring in the reference to compliance with community law. It's not in Article 28 of the 6th directive, and it goes back to Article 17 of the 2nd directive. But that didn't stop the European Court, when dealing with the infraction proceedings, of policing, looking at the choices to see if they tick the boxes that are in the 5th final
to
indemnity.
require compliance with community law.
Compliance with community law, exactly.
But so what principles come into that in accordance with community law? What comes in?
At least it is strict interpretation. At least it is the fact that this is a standstill because case law tells us that. It brings in legal certainty. These are the general principles of European law. It brings in fiscal neutrality, no doubt about that. Where I can't go, and that's why I've been saying it's persuasive and of assistance,
98.
I can't say that 98 is brought in by 110.
It doesn't
although they
bring
are-
in the definitions
Yeah.
in 98 into the fact that you may, in your 110...
They're closely linked, and when it comes to the exercise of the domestic principle of always speaking, that we say should have regard to the equivalent activity that is
Well,
happening.
that is the stage in the reasoning that puzzles me, Mr. Fleming. How do you have regard to something that is not applicable? I mean,
It's,
you're,
sorry, my lord, we say it is the context in which you examine whether or not there is here an extension, for example, and the extension you are informed by
well,
the fact that
I mean, if you're asking whether it's an extension, the answer is it can't be under European law. So you're not.
well, then that almost answers the strict interpretation, because if you look at newspapers which you accept is printed material, and then say, no, this covers electronic services, and you know that electronic services exist as a separate area of consideration, both in EU and domestic law by this time, because we've incorporated place of supply rules, then you can say, yes, there's always speaking, but it's always speaking in relation to a different or potentially extended item. That's why Harrier helps us, and not my learned friend, because Mr. Judge Berner had to start with asking the question, are these goods or services?
So you take into account the European legal regime, which acknowledges a clear difference between electronically supplied services and printed materials, or the electronic supply of printed materials.
Not necessarily because it's community law, but because it's the context in which you are considering whether or not to extend the meaning of a particular domestic provision, which is Europe permitted. It's Europe consented.
So Europe gave you permission to exclude or zero rate printed material. Then when you ask the question, has Europe in a later age, acknowledging the always speaking principle, given you permission to extend that to what we now know are digitally supplied services of the same content, you ask, well, how does Europe treat that distinction between digitally supplied services and printed content? And you say that Europe treats it completely differently, so it would be an impermissible extension to zero rating.
And that we now know is the published
Mr.
view.
Peacock doesn't agree with that
Well, no,
formulation, which I
that's
didn't.
why
I
he's-
did know, Mr. Peacock.
That's why Mr. Peacock is sitting over there. But that's why we also say, look at what the Commission and the legislature say in 2018.
Well, all that tells us is what I just said, which is that the European law makes a clear distinction.
Yes, and it also says that the obligation, which is one of the primary obligations of all member states, is to charge the standard rate, and that there's no derogation in Europe that allows you, member state, to charge less than the standard rate for electronically supplied services. That's what it states clearly in the Commission's proposal for a directive. We say that's right, but that's why we suggest...
But it's in the harmonised silo, so it doesn't matter, says Mr. Peacock.
Said Mr. Peacock, yes.
Well, we also don't know whether there is any acceding member state which previously did not apply its purchase tax to digitally supplied newspapers, and which therefore relied upon Article 110 before 2018 in order to maintain that in force. I don't know.
All I do know is what you've been shown is it was necessary to record in Article 111 that a cassette talking book version of a newspaper was a specific permitted derogation. We've been, just going back to fiscal neutrality and how it might work, bearing in mind we thought whether we could use our tomato example and decided it probably stops its usefulness. But what if the item 2 said back in 1972, or whenever it was first introduced, because it wants to protect education and information, but on a serious basis, newspapers excluding tabloids, that kind of tempting, it may never have got through Parliament, but assume that it did, we can see that within that category there could then be a fiscal neutrality argument. What you can't do is go outside the word newspapers, because fiscal neutrality isn't an interpretive tool. In this context, I keep repeating myself and probably getting...
Well, I think that example is a difficult one, but yes.
Could I just do what, unless you have any questions, Lord, could I just give you the references for lines drawn by the fiscal neutrality can't extend the categories. You've had Talaka Beach, but could I go through give you the references and say nothing more? It says the scope of a reduced rate, this is the summary, as with any other exemption, cannot be extended by the principle of fiscal neutrality, and then these words you'll see appearing in the case law, in the absence of clear wording to that effect. And the cases are the État Belge, which is page 255 of your authorities, paragraphs 30 to 32, Commission against Luxembourg, which you've already seen. There's the use of the word unequivocally, and it's page 201 at 208. And for the zero rate, it's the Advocate General in Talaka Beach, at paragraphs 39 and 42, which is page 81 and 89 and 90. And the Court at paragraphs 16 and 22, very clear terms, which is page 81 at pages 92 and 93.
Yes.
My Lord, unless I can assist the Court further, those are our submissions.
Well, thank you very much, Mr. Fleming, and thank you very much, Mr. Peacock, and your juniors and solicitors for what has been a fascinating couple of days of argument. It won't surprise you to know that we're going to take time to consider our judgments, and we have much to think about. We will hand them down in the usual way, and then you will please agree an order and any consequential costs or anything else. If you can't agree, that argument will be conducted in writing, and we will deal with it on paper, and there'll be no need for anybody to attend at the hand down, which will very likely be done electronically in any event under the usual modern practice. So thank you both very much.
All right.